Hello, my name is Gonzalo Santos. I'm an associate lawyer at Ethica Abogados, a boutique law firm based in Spain, specialized in intellectual property, IT law, and e-commerce. I am specialized in particular in the fields of intellectual property, entertainment, and electronic businesses, and that's exactly what we will be discussing today, the preventive legal aspects that could have an impact on a business operating through electronic networks, i.e. an e-commerce business. The topics that we will cover in this lesson are the following. First of all, we will delve into what is e-commerce, just a brief definition to clarify the key business concepts that we will have to consider before entering into the more legal aspects. After that, we will discuss the different types of e-commerce, since each one of them can have different legal implications. Then we will move on to electronic agreements, which are a key component of transactions that are performed through electronic networks. After that, we will analyze the data protection issues that can arise for an e-commerce business, cookies and other tracking technologies, which are also intimately related to data protection and privacy, commercial communications, which, as all of us know, are an essential tool for electronic businesses in order to create a stable client base, intellectual property, which has a major impact on many different aspects of e-commerce businesses, cybersecurity, and finally, just a brief analysis of how criminal law can have an impact on a business that operates through the internet. First of all, it is very important to define what we understand as e-commerce. Following the definition of Investopedia, electronic commerce or e-commerce is a type of business model or segment of a larger business model that enables a firm or individual to conduct business over an electronic network, typically the internet. From this definition, we can already isolate a number of concepts. First of all, we have the idea of a business model. A business model, as such, can be understood as the way a business operates. Of course, different business models imply different legal risks. So we must bear in mind that an e-commerce business does not face the same legal issues and problems that a more traditional or physical business. Of course, then the definition goes on to clarify that the whole model can be, well, the e-commerce section can be the whole model or just a part of a bigger model, as we will see also later on in this class. So what we just mentioned of having specific legal issues that only affect electronic businesses might only impact a very, very limited or specific part of a company's operations, which might also take place in a physical medium. And finally, the final part of this definition is extremely important in today's economy because it distinguishes between firms and individuals. Both companies and natural persons can actually act both as users of an e-commerce service or as providers of that service. As we all know, there are a number of cases of what has become known as collaborative economy, in which consumers actually render services to other consumers, and that has a specific set of legal implications that have to be considered. Here we can see a very typical e-commerce workflow diagram. As you can see, there are many different players involved in a single transaction and many different steps until a product or a service is finally delivered to the purchaser of said product or service. Each of these steps involves legal risks, whether it is shipping a product, whether it is ensuring the security of a credit card payment. All of them have to be considered and analyzed individually in order to create a preventive law framework that is actually effective and minimizes the risk of claims or sanctions from public authorities. It is in fact critical also to identify the different players that are involved in our particular business model. For example, it's, as we will analyze later on, it's not the same for two businesses to actually interact with each other than for a business to directly interact with consumers, since different legal aspects have to be considered, and also there are different legal tools available to each of the parties in the event of a claim. Moving on to the different types of e-commerce, there's another definition of e-commerce that I particularly like, which is e-commerce can also be defined as a transfer of goods, rights, services, or funds using different technological tools in order part of the process. Now, this is something that the previous definition from Investopedia did not foresee, which is that e-commerce can be a part of the whole transaction or just a small segment of it. Again, if it's a small segment, then there are another set of legal implications that will have to be analyzed independently from that particular segment that is strictly an e-commerce transaction. Of course, e-commerce can be classified based on a number of criteria, each of which can have an impact on the legal framework that must be considered. As we mentioned earlier, different business models within the definition of e-commerce, as we will see now. You can have an online shop that sells tangible goods. You can have an online video service. Again, completely different worlds when it comes to analyzing the potential legal risks that can occur. But finally, as you can see here, some of the most used criteria, again from a business perspective, but it will have an impact on our legal analysis, are the following. The subjects involved in an e-commerce relationship. For the purpose of this class, we will always speak of from a buyer and seller perspective, which can be understood as buyer as someone who acquires a product or service, and seller as the provider of that product or service. Although, of course, there are different types of buyers and sellers, as we will see later on. E-commerce can also be classified based upon the products and services that are provided to those buyers, the sales system, the platforms used, or even the environment in which the products or services can be used. Well, pursuant to the subjects involved in a commercial relationship, e-commerce can be divided into the following types. B2A, business to public administration. An example of this could be an IT company providing hosting services to a public body. Of course, B2B, which is business to business, in which two companies within the private sector interact with each other. For example, an IT company that hires another company for the latter to provide cybersecurity services. Then we have B2C, business to consumer. This is probably the type of e-commerce that is more commonly known to all of us. Classic example, Amazon. You simply purchase a product through the internet and it's delivered to your doorstep. Then we have B2E, which is business to employee. This form of e-commerce is not very well known, but again, it's extremely important since it's becoming very predominant. And finally, C2C, consumer to consumer, collaborative economy. There are many examples of this type of e-commerce model, such as Uber or Airbnb, in which individuals actually interact with each other and render services to each other thanks to the intermediation of a third party. Moving on to B2A, business to public administration. Well, although public administrations are not usually commercial entities, it is possible for them to interact with businesses in order to acquire services and goods through technological means. For instance, a public administration may hire a cloud-based storage service managed by a private entity, as we mentioned earlier. In these cases, it is extremely important to bear in mind that a public entity is usually subject to a specific set of laws when it hires a private contractor, which means that Of course, said regulations will have to be considered when entering into an agreement with a public body. In particular, standardized terms and conditions may have to be amended in order to comply with the aforementioned regulations and to enable the provision of a service or the supply of goods to the corresponding public entity. Of course, this limits the ability of the parties to negotiate, and it means that usually public administration will be in a much stronger position when it comes to imposing its own terms. And it is also very important to consider some ancillary aspects which are usually ignored when contracting with public entities, such as, for example, ownership over intellectual property rights, since certain jurisdictions have regulations which establish, for example, the automatic transfer of ownership to the public administration that's receiving the service, even though it's not specified in the contract. These are aspects that must be carefully considered, again, not only from a purely contractual perspective, but also from a regulatory one. Moving on to B2B, this type of e-commerce is becoming increasingly common, which wasn't, it wasn't as usual for companies to interact only through telecommunication networks, but again, it provides a lot of agility, a lot of flexibility, and it simply makes everything quicker for companies. Of course, another factor that has led to the rise of B2B e-commerce is that companies are becoming more eager or more ready to outsource key services that were usually performed in-house. For example, cybersecurity, as mentioned earlier, or cloud management. This type of services were usually performed within the infrastructure of a company because they were considered to be critical for day-to-day operations. Nonetheless, thanks to the specialization of third parties, companies that exclusively provide these services, many companies have found that it's actually more efficient for them to outsource them. Moving on to the purely contractual aspects that have to be considered, B2B relations are usually based on the free will of the contracting parties, since they are both private entities. Thus, special regulations will only apply to specific services or products. For example, let's say if we're talking about a company that operates within a critical sector for the economy of a country, such as energy or electricity supply, there might be some obligations that will still have an impact on its ability to hire services from a private contractor, of course. But if we're talking about companies that operate in sectors that are not very regulated, for example, two IT companies, then, of course, the free will of the parties will be the main element that will have to be considered when negotiating or drafting an agreement. Of course, there are other aspects, such as data protection, which may have an impact on the provision of the services, but those are purely regulatory aspects. I mean, it is very important to differentiate between the contractual issues that can arise and the strict compliance issues that could come up. One of them, contractual issues are negotiable between the parties. Compliance with regulatory issues usually is not. And that's where the most important risks can arise. Moving on to B2C, or the more classic e-commerce model that we all know. It's simply interaction between a business, a company, and a consumer, which is, of course, a natural person. Even though some legislations, in some cases, actually consider some type of businesses as consumers for protection purposes when negotiating with some type of companies. For example, it was discussed in the European Union a couple of years ago whether companies should be considered consumers when accepting the terms of service of big IT companies that pretty much didn't allow anyone to negotiate the terms, for example, of under which a software is licensed. But nowadays, at least in most major jurisdictions, the concept of consumer pretty much is equal to a natural person. Transactions between consumers and businesses, of course, usually trigger the application of general consumer protection laws and sector-specific regulations that can vary depending on the product or service being provided. Again, for example, food safety laws. Amazon actually launched some time ago a grocery shopping service in which food and other goods that are consumed by their customers were shipped directly to their house. Each business line in an e-commerce business can open a new path that has to be analyzed not only from a business perspective, but of course from a legal perspective, since it can imply additional obligations. Moving on to data protection laws, of course, they play a crucial role in B2C transactions, since personal data needs to be processed for a purchase to be completed. Again, all of us, when buying something through the internet, have had to go through this sometimes endless forms in which we are required to provide our personal data for the company to be able to provide us with a good or a service, such as our address, our contact phone number or email. I mean, all of that is part of the personal data of a user, and as such, it has to be protected. And again, whenever a company receives it or processes it, that triggers a set of obligations that we will analyze later on. Of course, considering the above, businesses cannot freely impose a set of conditions that consumers must accept. Instead, they must take into consideration specific laws that regulate this type of transactions. This means that companies do not have much room for negotiation when dealing with a consumer, since their hands are pretty much tied by consumer protection laws and other regulatory aspects that they have to consider. The reason for this, of course, is that the consumer usually is in a much more weaker position. B2E, business to employee, this form of e-commerce is not very well known, but it's becoming increasingly important since it allows companies to directly interact with their employees. Huge difference with other forms of e-commerce. This one usually takes place through a closed network within a company, which of course means that certain obligations that might be applicable to internet-based commerce might not apply in this case. Nonetheless, of course, some aspects of employment or labor laws might have to be considered when determining which products and services are offered to employees and how they are offered to employees. Because B2E e-commerce is commonly used to allow employees to manage benefit plans, specific products and services offered by their employer, most of the time at a reduced price, or before they're available to the general public. This is important since products that are offered to employees are usually not third-party products. They're usually products that the company has procured or manufactured, which somehow limits the level of risk since if something fails, it's a product that the company has, let's just say, manufactured or directly made ad hoc for the employee. It's different, of course, if the company provides a third-party product. Then we have the following question. Can the employee actually take action against the company for a defective product that was in turn provided to the company by a third-party provider? That will have to be analyzed, of course, attending to different national laws. And finally, C2C, consumer to consumer. This is a quite recent phenomenon, of course, but it's becoming more and more common due to the usually low prices and pretty much increased flexibility for both parties. The increased flexibility for consumers interacting with each other, of course, comes at the price of bigger risks in transactions. How is this solved? Well, usually C2C transactions take place through an intermediation network that is provided by a third party, a company most of the time. Companies in this case have a set of terms and conditions that bind the consumers that access this intermediation platform. Therefore, consumers have to accept those terms and conditions before actually using the platform and before being able to interact with other consumers. This provides a minimum degree of contractual security to the parties, but it must be borne in mind that for the company providing that platform or network, it is crucial to draft those terms and conditions in such a way that their liability is limited as much as possible. Since if there are any claims, consumers usually take action not against the other consumer, but rather against the intermediary, who they see as some kind of grantor of the good faith of the other party, which is most of the time is not the case. And this must be made very clear, again, in the terms and conditions that a consumer accepts. Of course, it must also be noted that clauses limiting liability might not be enforceable in some jurisdictions which are particularly protective with consumers. Moving on to the next classification of different e-commerce businesses, e-commerce can be divided into the following categories pursuant to the types of goods and services provided. We have tangible products, for example, furniture. If you buy something from IKEA, I don't know, a chair from IKEA, that will be an example of an e-commerce business based on the sale of tangible products. Intangible products, for example, Steam, which is a platform for acquiring video games, but only a digital copy of those video games. Streaming services, Netflix, HBO, and of course, other services, which we will discuss later. Regarding tangible products, this is probably the most common form of e-commerce, since, again, it consists in the sale of goods through electronic means. This type of e-commerce is based on a transfer of ownership over a tangible good. Following our previous IKEA example, whenever I purchase something from IKEA, I'm acquiring ownership over that piece of furniture. Again, it is common for consumer protection regulations to allow the return of goods acquired through electronic networks within a brief period of time. Of course, this is due to the fact that the buyer can only check and try the product once he or she receives it. This means that the purchaser cannot actually see or test the product before buying. It can only do so before completing the purchase. Of course, if the goods are damaged due to the negligence of the buyer, their right to return them will be considerably limited. But also, it is very important to bear in mind that there are some limitations to the above regarding custom-made products, since the resale potential is very limited. For example, so let's just say that instead of buying an IKEA chair, we actually order a carpenter to build a chair for us, a custom-made chair. If we don't like that chair, the carpenter cannot resell it. Therefore, it would not be logical for a consumer to have the right to return that specific product. Moving on to intangible products, this type of e-commerce is becoming increasingly important. It consists in the purchase of a license over a product which must be used within an electronic environment. In this case, the buyer does not acquire ownership over a specific product, but rather a right to use a copy of that product. Following our previous examples, Steam, that video game service we mentioned, in this case, users can download a copy of a video game, but they do not have that video game physically. They simply have a license to use it. The same could be said from audiovisual content service that allows users to download videos. Of course, the right of consumers to return goods in this case can be more limited, since information on the specific functions and technical requirements of the licensed product are usually made available by sellers, and therefore it is very difficult to argue that the buyer did not have a chance to know in advance whether that product met its needs or whether he was able to check it, since most of the time when we're talking about intangible goods, users do have the possibility of trying beta versions or demo versions that actually allow them to test the product in advance before buying. And we move on to streaming, which is, it could be considered as part of the previous category, but it's becoming so important that it's actually quite important to analyze it separately. As you can see, this model has really disrupted or even destroyed the ownership-based model on which e-commerce was based before. Here, purchasers do not even acquire a license. They are only granted the right to access a technological platform or tool, which in turn contains a specific set of functions or content. But the user never acquires a license over said content. Instead, again, he simply has a right to access. It is usually a subscription-based model, of course, in which the buyer pays an annual or monthly fee. And it's quite flexible since, again, following consumer protection laws, the consumer usually has the ability to unsubscribe at any time. This is very important since depending on how the terms and conditions of a service of this nature are drafted, this might allow the user, first of all, it might allow him or her to unsubscribe at any moment without being obliged to pay any further fees, or in fact, if the terms of service are not properly drafted, it might even lead to an obligation for the company to actually refund any fees that have been paid for services that have not been, in fact, rendered. A classic example of this, let's just use Netflix. Let's just say if a Netflix user has an account and he or she cancels that account or unsubscribes from the service on the 15th of March, and he owes Netflix $10 for that month. If the terms of service are not properly drafted, the user could even argue that he doesn't owe Netflix $10, that in fact only $5 are allowed to Netflix. It is quite an extreme case, you could say, but again, there are other types of services which actually charge much higher fees, and that can have a definite impact on the on the income of a company. So it is, again, extremely important to bear in mind how the terms of service that a user accepts are drafted. And of course, here we indicate that usually the purchaser doesn't have a right to request the return of any paid amounts, but again, it will depend to a very large extent on the terms and conditions that the user accepts. Finally, we have this broad category named other services. These are services which were usually hired through physical means, but they can now be contracted through electronic networks. Most of these services can be technology-based, or in fact can be more traditional services. For example, the food delivery, pretty much shopping groceries over the internet. Consumers do not usually have a reimbursement right as such, since that would imply that they would actually be benefiting from a service effectively provided to them at the expense of the service provider. Now, the reason for this is of course very positive for a business, since it limits their liability and it weakens the consumer or the user's position. The reason for this is that let's just use as an example. If a user hires plumbing services through the internet, those services are actually rendered in the physical world, so to speak. Therefore, the consumer or the user can actually verify how those services are rendered. And once they are rendered, if they have been, of course, rendered diligently, he or she does not really have a legal basis to claim, to file a claim or take action against the provider or to request a refund. Again, since all due to the fact that he or she has been able to verify how and when they were provided. Unlike our previous example of Amazon, in which a product cannot be tested or cannot be checked, to put it in a way, before it is actually delivered to the user. Again, another classification for e-commerce businesses is the sales system they use. The price of a product or service in an e-commerce environment can vary depending on whether it is sold for a fixed price or not. Therefore, two major types of e-commerce can be distinguished based on the system used to determine the price of a product or service. The price can be fixed, or the price can vary based on bids placed by users, which is an auction. In a fixed price model, the price is set from the moment in which the buyer accesses the platform through which it may purchase the corresponding product or service. Of course, notwithstanding the above, the price may vary depending on a number of factors, such as demand, of course. Good example of this is flights. The more you search for a flight or for a hotel reservation, the more the price will increase. And the reason for this is that companies use technologies such as cookies or web beacons to track user behavior and deliberately increase that price. Of course, the use of these technologies can have an impact on the privacy of purchasers, which must be considered when implementing them in order to ensure compliance with applicable data protection regulations. Moving on to the auction model, here the price of a product or service will vary depending on the bids of potential buyers. Classic example, eBay. In this case, the price of the product may not be changed through tracking user behavior, of course, but this does not mean that cookies and other similar technologies cannot be implemented to analyze how users interact with a platform through which sales are made. Even though the final price of a product or service will depend on the bids placed, i.e. this means that the final price will depend on the actual users, consumer protection regulations may establish an obligation to provide bidders with information regarding the potential final price thereof, taking into account other factors. For example, shipping costs. Again, following the eBay example, usually when you're browsing products in eBay, you will find not only the latest bid placed by someone, but also the increase in cost derived from shipping fees, for example. This is very important since, again, consumer protection regulations usually, well, in many jurisdictions, set forth an obligation for companies to pretty much lay out all potential costs for users in order to avoid a consumer paying any unwanted costs of which he or she was not aware before completing a purchase. We move on to the platforms used in e-commerce businesses. As we mentioned earlier, e-commerce can take place online or in a combination of digital and physical environments. Of course, pursuant to this criterion, the following types of e-commerce exist. First, we have e-tailers, and then what is commonly known as click and mortar. E-tailers are pretty much as it can be inferred from their name, a retailer that sells goods through electronic transactions. Again, Amazon is the classic example. These businesses have to consider a set of regulations mentioned earlier, such as consumer protection, privacy, etc., of course. And then we have click and mortar businesses. This is a combination of the e-tailer model with physical shops in which users can test and purchase products. In fact, another example of this is Amazon, which is in fact opening some shops, some physical shops, because they have found out that they are more appealing to some consumers and they don't want to miss out on that specific segment of the population. Since these businesses also have a physical presence, they have to consider all of the previously mentioned legal aspects that have a direct impact on e-commerce and those regulations applicable to traditional shops. For example, real estate regulations or regulations that limit the opening hours of businesses. And finally, we have the last category of e-commerce businesses, which is based on the environment in which the products or the services purchased by users can be used. And here we can distinguish between those products that can be used in an open environment or in a restricted environment. Products or services purchased by the buyer, in this case, can be used wherever the buyer chooses. Going back to our IKEA example, if I buy a chair, I am free to use that chair wherever I want and whenever I want. It is very important to specify here in the terms and conditions accepted by the buyer whether it is possible to freely use the products or not. Not doing so could even render the agreement between the seller and the buyer invalid. This is crucial since although it can be inferred sometimes from the service itself, from the e-commerce service, it is important to lay down this type of issues so that consumers are aware of them, and in the event of a claim against the company can actually argue that it did not hide this limitation from the claimant, and that it was in fact the claimant's responsibility to read the terms of service and to make his purchasing decision knowing that certain limitations on the use of a product or service existed. Here, a buyer may accept the terms and conditions regulating a purchase of goods and services on a case-by-case basis. For example, again, IKEA, for example, has an option in which you can actually accept those. You don't need to create an account. Those terms of service can be accepted with each purchase. Or, in fact, which is the Amazon model, users are required to create an account in the e-commerce service in which they accept that those terms and conditions will apply to all future purchases. Finally, we have restricted environments. In this case, products or services purchased by the buyer may only be used within a specific technological environment. For example, streaming services. HBO or Netflix are good examples of restricted environment service, since the content of Netflix and HBO cannot be accessed by users outside of their website or their applications. The use of a restricted environment implies, of course, the existence of a continued relationship between the buyer and the seller. In this case, it is logical to actually use the Amazon model. In fact, i.e., this means that the user accepts a set of terms and conditions that will govern his or her use of the service continuously. Consequently, if said terms or conditions are amended, they have to be provided to the purchaser or the user of the service so that the amended version can be accepted. If they are not provided to the user, their validity might be challenged. Now, we move on to electronic agreements. E-commerce, of course, usually implies that the contracting parties do not execute an agreement face-to-face. Instead, legal relationships are established through electronic networks. There are a number of key elements that must be taken into account in any type of agreement, but some of them are particularly important in an e-commerce environment. Said elements are information, of course, consent, capacity, purpose and scope, and applicable law and jurisdiction. Information requirements are usually established in consumer protection regulations, so that's why they're especially important in a B2C scenario. This means that consumer protection laws must be borne in mind when drafting the terms and conditions of an e-commerce service, and even when displaying products and prices in a website, since regulations in certain jurisdictions set forth specific aspects which must be expressly mentioned in set texts. For example, whether any purchased goods or services are subject to a guarantee, or whether the user has a limited period of time to return a product. That could be another example. Moving on to consent. In the physical world, again, so to speak, as we all know, consent is usually expressed through the signature of the parties to an agreement. But in the case of electronic contracts, there is not a physical document which can be signed by hand, although there are other mechanisms which allow to verify whether a party has in fact given his or her consent in this regard. Some of the aforementioned mechanisms that are more commonly used are consent forms, that we mentioned earlier, and checkboxes, and electronic signatures. Of course, the validity of each of these systems can vary in each jurisdiction and should be verified prior to their implementation. Not doing so could lead to a very complicated scenario in which consumers or users could actually challenge the validity of a contract or a transaction based on the unlawfulness of a specific consent system. Consent forms and checkboxes are probably the most commonly used systems in order to obtain consent, especially in B2C and C2C transactions, since, well, they do not require the implementation of a very complex technology. They're quite user-friendly. They simply require a user to scroll down a set of terms and conditions or check a box, an acceptance box. Although it is a simple consent mechanism, its validity may be challenged if not implemented correctly. For example, in some jurisdictions, checkboxes for expressing acceptance cannot be checked by default, and instead must be checked by the user. This means that opt-out systems in which the terms and conditions are accepted by default are not valid, because it is understood that the user has not made a conscious decision to accept those terms and conditions, that in some way the provider of the goods or services is imposing them on the user. In order to ensure compliance with the laws of each territory, businesses can use legal or technological tools or a combination of both that we will analyze right now. A more legal-based approach to solve the problems derived from the application of different national regulations is to set up a consent mechanism which meets the minimum requirements of all the territories in which a particular business will operate. Nonetheless, the effectiveness of this system depends on the implementation of technological measures which prevent users from other territories from accessing the e-commerce service, for example, geo-blocking. If these technologies were not implemented, of course, we could have the following scenario in which a user from a territory that has not been analyzed from a legal perspective accesses a service, completes a transaction, but yet is bound by a set of terms and conditions which are likely unenforceable in the territory from which the transaction has been performed. This, of course, weakens considerably the position of the provider of services or goods. Of course, having said this, some territories like the European Union are currently drafting laws which would limit the ability of businesses to implement geo-blocking mechanisms, which can make this approach much more complex. Ensuring compliance with national laws can also be achieved through a more technology-oriented approach. For example, a mechanism that is commonly used consists in redirecting users to a country-specific websites in order for them to be bound by a set of terms and conditions specifically drafted to comply with the regulations of their country. By doing this, we solve the unenforceability problem that was mentioned earlier. This is usually achieved, of course, the redirecting, through the identification of IP addresses. However, like the previous system, this one has some flaws. First of all, it is necessary to draft different terms and conditions for each jurisdiction, which can be time-consuming, and it's not, of course, a bulletproof solution since laws are constantly being updated. And it would mean that whenever a country's legislation actually went through changes, those changes would have to be implemented for that specific country, and then that same action might have to be performed for a very, very considerable number of territories. Also, IP identification mechanisms can be avoided through the use of VPN technologies, which are virtual private networks. These technologies they are used for hiding the IP address of a user by giving them the IP address of a different country. And finally, identifying the IP address of users could trigger additional obligations from a data protection standpoint, since in certain countries, IP addresses are considered personal data. Another consent mechanism that we mentioned earlier is electronic signatures. This technology seeks to replace handwritten signatures in electronic agreements, of course, but not all electronic signatures have the same validity as a handwritten one, since most major jurisdictions have laws which establish a number of requirements that an electronic signature must meet in order to achieve such status. The aforementioned requirements seek to ensure the security of electronic signature systems in order to prevent online fraud and to provide additional guarantees to the contracting parties. It is very important to determine which type of electronic signature is being used in each transaction, since it could have an impact on the validity of the agreement between the parties. And of course, could make it easier or more difficult to challenge that validity. Well, again, as in face-to-face agreements, capacity is a vital element of electronic agreements. But it can be difficult to determine whether a contracting party has sufficient legal capacity to enter into an electronic agreement due to the fact that none of the parties can physically see each other. Since the agreement would not be valid in the event that the parties did not have sufficient legal capacity to enter into it, it is crucial to implement mechanisms which allow to, of course, reasonably verify this aspect. In order to make the purchase process as user-friendly as possible, Capacity requirements, such as the minimum age required to enter into the corresponding agreement, are usually established in the terms and conditions that a buyer accepts. Nonetheless, there are some specific cases in which reinforced verification mechanisms might be required, such as the sale of alcoholic drinks or accessing an online gambling service. In order to mitigate any risks in this regard, since no identification system is completely bulletproof, it is common to include in the terms and conditions of an e-commerce business liability limitations in case certain products or services are accidentally provided to purchasers who cannot have access to them. In the case of underage purchasers, it is also common to include in the applicable terms and conditions that their parents or legal guardians will be responsible for any purchases made by the minors. In the event of a claim, it is likely that the main criteria to determine the degree of liability of the seller will be a combination of the level of enforceability of the aforementioned clauses and whether it acted diligently to ensure that inappropriate products were not being sold to a minor. This means that if adequate age verification systems are in place, then the risk of a claim against the business being successful will likely be lower. Moving on to the purpose and scope of electronic agreements, this must be clearly indicated in the terms and conditions accepted by users in order to mitigate the risk of potential claims, of course, and also to limit the risk of undue returns of products. This aspect is particularly sensitive in B2C transactions, business to consumer, since national laws may establish sanctioning mechanisms against companies in the event of breach of the terms accepted by the user, since said breach may imply a violation of consumer protection laws also. This means that businesses face two main risks. On the one hand, claims from individual users, and on the other hand, sanctioning proceedings from public authorities. Also, class actions must be mentioned, since they must be considered an especially important risk, because they can have a severe reputational impact for a business and can considerably weaken the position of a company from a negotiation perspective. It is not as easy for a company to negotiate with an individual customer than to negotiate with several customers that have joined together in order to take legal action against the company, of course. Now we move on to the applicable law and jurisdiction. In B2B transactions, the parties may usually choose whichever applicable law they wish. But in B2C scenarios, this might not be possible, since consumer protection laws in a number of jurisdictions establish that it is compulsory for an electronic agreement to be governed by the laws of the country where the consumer is based. Even in B2B transactions, there are aspects of national regulations which must be taken into account, since they could render certain provisions of an agreement unenforceable. For example, provisions refer to limitations of liability or payment periods. Similar considerations are applicable to the choice of a particular jurisdiction to solve any controversies. In fact, some jurisdictions even set forth as compulsory, as the compulsory jurisdiction, arbitration tribunals that settle disputes between businesses and consumers. Regarding data protection, as we mentioned earlier, e-commerce transactions imply necessarily the processing of personal data in most cases, since purchasers need to provide sellers with their contact details in order for the latter to identify them and to ensure the correct delivery of products and services. Collecting and processing personal data triggers the application of specific legislation, which establishes a number of minimum guarantees to safeguard the right to privacy of data subjects. Although data protection regulations can vary considerably between different territories, Many legislators around the world have used the legal framework of the European Union as reference, since it guarantees a high level of protection for data subjects. Of course, this high level of protection also means that there are a greater number of obligations for companies. The following aspects are key when determining the degree of compliance with data protection laws: information, consent, types of personal data being processed or the processing activities being performed, data transfers, and security measures. Data protection laws usually establish a minimum level of information that must be provided to a data subject regarding the processing of his or her personal data. Some aspects that are usually required to be disclosed to data subjects are the entity that will determine the purpose for which the personal data will be processed, which is commonly known in data protection laws as a data controller. This will usually be the company in charge of collecting the personal data, in this case the e-commerce business, the purpose for which the personal data will be processed, in this case the provision of goods or services, third parties to which the personal data will be disclosed, typically third parties that actually provide marketing services, for example, to an e-commerce business, the territories to which the personal data will be transferred, which we will analyze in more detail later on, and finally, the rights as data subjects of users. In order to fulfill applicable information obligations, it would be advisable to include in the e-commerce platform a specific privacy policy. Even though some national laws might allow to include data protection related information in the general terms and conditions that govern an e-commerce service, having a separate document that covers these aspects would make it easier to argue in the event of a claim that all the legally required information was clear and easily available when the data subject gave his or her consent for the processing of his or her personal data, and that therefore information obligations have been correctly fulfilled. Here, in the event of a claim, it's always a test of how diligent a company has been when fulfilling its obligations in this regard. So again, it is extremely important to create this trail of paper, so to speak, or in this case, this trail of bytes, in which allows the data controller to prove that the user had all the information there and that it was his or her choice to either ignore it or not to pay the sufficient attention to it. Regarding consent, well, as a general rule, data subjects must give their consent for their personal data to be processed. The most common consent mechanism in physical transactions is the execution of a paper document that meets the aforementioned information requirement. However, in electronic transactions, other mechanisms have to be implemented. Said mechanisms will vary depending on whether the data subject's consent is explicit or implied. Implied consent mechanisms are becoming less common since data protection regulations are constantly being reinforced in order to protect the privacy of individuals in the face of technological changes. Consequently, implementing explicit consent mechanisms such as an unmarked checkbox through which a user can express his or her consent or his acceptance of a privacy policy would be the safest approach to ensure compliance. This might be more cumbersome from a commercial perspective, but it is safer from a legal one. Moving on to the considerations that have to be borne in mind regarding the types of personal data being processed or the processing activities being performed, it must be noted that processing certain categories of personal data may trigger the application of more stringent obligations for data controllers. The same would apply, of course, to some specific data processing activities. The aforementioned types of personal data are usually those considered to be particularly sensitive. Some examples are the following: religious beliefs, ethnic origin, health, or sex life. At first, it might seem that most of these personal data would not be processed in the context of an e-commerce transaction, but there are cases in which they may be inferred from the context thereof. For example, when purchasing medicine or some specific products, and this could trigger the application of specific rules pertaining to the processing of particularly sensitive personal data. In order to avoid the above, it would be highly advisable to limit the types of personal data being processed to those that are strictly necessary in order to perform a transaction. For example, email address, phone number, etc. Some data processing activities, regardless of the type of data being processed, may be considered as particularly privacy invasive, especially activities that are usually performed by e-commerce businesses. Consequently, additional obligations would apply to guarantee the privacy of individuals. One example of these activities is profiling, which is a technique commonly used by e-commerce businesses in order to improve the functioning of a website or platform. In order to avoid triggering a more stringent set of obligations, it would be advisable to only process data in aggregate form, which means that only data consisting of raw numbers that cannot be associated to a specific individual are being processed, or, if possible, data that is completely anonymized, which means that an individual cannot be identified in any way simply by looking or processing that personal data. In the middle ground, we have pseudo-anonymization, which means that data has been anonymized, but that anonymization process can be reversed. Therefore, by applying some data processing techniques, a company could find out the individual behind a previously anonymous set of data. Well, pseudo-anonymization would usually still trigger the application of data protection regulations, because, as mentioned, it is a reversible process. Concerning data transfers, well, e-commerce businesses, of course, usually provide goods or services to users located in different territories. Consequently, information containing personal data is likely to be exchanged among business entities located in different countries. The level of personal data protection can vary considerably from one jurisdiction to another. This has led legislators to establish additional obligations for data exporters in order to ensure that data subjects are fully aware of this issue when giving their consent for the processing of their personal data. Notwithstanding the above, there are areas in which personal data may be freely transferred across different territories. For example, among member states of the European Union, which share a common level of data protection. Finally, security measures are especially important since they are the mechanisms that allow to safeguard personal data. And data protection regulations usually establish obligation to have in place these security measures. These laws can either establish a general obligation to implement security measures, or they might set forth more specific criteria, such as specific measures that have to be implemented by companies depending on the type of data processed, the processing activities performed, or other factors. Having in place security measures can be cumbersome, of course, for a business, since it can hinder IT operations, but it is a preventive element that allows to reduce the risk of data breaches and even sanctions, since a company can effectively prove a high level of diligence and care when processing personal data, if, of course, has these security measures in place. And finally, just to finish off with data protection, some general considerations. First of all, data protection obligations can limit the ability of a business to perform certain activities, of course. And consequently, the mechanisms through which a business complies with said obligations must be assessed using a risk-based approach, taking into consideration both the impact on the business and the potential risk of claims or sanctions. Sanctions for breaches of data protection laws can be extremely high, amounting to several million euros in territories such as the European Union, and can even lead to criminal liability in some jurisdictions. Cookies, we mentioned them earlier. They are technologies or tools which allow to track user behavior in electronic networks, and they are closely tied to data protection. Because depending on how they are configured, they can be very privacy invasive or simply collect anonymous browsing data, raw numbers, as we mentioned earlier. Cookies are commonly used in e-commerce platforms since they allow to provide users a smoother service by tracking their preferences. For example, by serving targeted advertisements or remembering their login details. Since the use of cookies usually implies some kind of personal data processing, privacy and e-commerce laws set forth obligations to adequately inform consumers of their implementation and purpose. Information obligations regarding cookies usually require the implementation of a two-layer information system, consisting of a cookie banner and a cookie policy. The cookie banner is the first layer of information to which users have access. It is commonly displayed when a user enters a website and informs him or her of the use of cookies. In order for the information available in this first layer to be as complete as possible, it is advisable to include in the banner a hyperlink to the cookie policy. The cookie policy should contain more detailed information, such as the purpose for which the data collected through the cookies is processed, whether the cookies belong to the owner of the website or are provided by a third party, etc. It is also very important regarding cookies, especially cookies provided by third parties, to bear in mind that personal data might be transferred to another country. This usually must also be, well, this aspect must be included also in the cookie policy aside from the privacy policy in order to make sure that the users have no excuses as to whether that information was not readily available. Commercial communications are a vital part of e-commerce, and they may be defined as any form of communication designed to promote, directly or indirectly, the goods, services, or image of a company, organization, or person pursuing a commercial activity. This type of communications are essential for e-commerce businesses, since they allow them to contact directly with users and potential users in order to provide them with information about their products and services. However, in many jurisdictions, commercial communications are heavily regulated in order to deter businesses from sending a disproportionate amount of them, which is commonly known as spam, or to limit the recipients to whom they are sent. One of the most common requirements to lawfully send commercial communications is having the consent of the recipient, although in some jurisdictions this may not be necessary in certain cases. For example, when a business relationship exists between the sender and the recipient, and the communication refers to products or services similar to those already acquired by the latter. The most common system to obtain user consent is the use of a checkbox. But it must be noted that in some jurisdictions, said checkboxes cannot be checked by default, since this would invalidate user consent. Moving on to intellectual property, this plays a major role in the e-commerce industry. Most of the elements of an e-commerce platform, as well as the products and services sold through it, are affected by different intellectual property rights. Intellectual property is a broad concept that encompasses the following rights: copyright, trademarks, patents, and design rights. Regarding the concept of intellectual property, it is very important to note that in some countries, trademarks, patents, and design rights are defined as industrial property. Regarding copyright, key elements of an e-commerce platform, such as the source code of the software which sustains it, can be protected through copyright. Moreover, some e-commerce services rely heavily on copyright-protected products, which can be particularly sensitive, since their correct exploitation requires the implementation of technological measures in order to ensure that the terms of the license and under which they are being used are not breached. For example, some of these tools can be IP identification and geo-blocking, since a business has to ensure that certain users cannot access contents that have not been licensed for a specific territory. A good example would be Netflix, whose catalog will vary from jurisdiction to jurisdiction. Finally, user-generated content can also be problematic in this sense, since an electronic platform may be wrongfully used by users to breach third-party copyrights. In order to prevent a copyright breach arising from user-generated content, it is important to clearly establish in the terms of service that users must accept that they are the only ones responsible for the contents they upload to the service. And although it might seem counterintuitive, in major jurisdictions, such as the US or the European Union, internet businesses are not liable for an illegal content hosted in their platform insofar as they are not aware of its existence. This is commonly known as safe harbor provisions. Consequently, it is highly advisable not to specify in the terms and conditions applicable to the service that user-uploaded content will be reviewed, but rather that the owner of the service reserves the right to review it and remove it at its sole discretion. Trademarks are, of course, also very important for e-commerce businesses, and their main function is to allow consumers to clearly identify similar products in the market. Consequently, trademarks can have an impact on an e-commerce business itself and on the products and services that are offered through it. Regarding the business itself, it is important to ensure that the trademark that allows to distinguish it from its competitors is adequately protected by registering it in those territories where the company operates. Regarding the products and services offered, the main impact of trademarks on e-commerce is the existence of counterfeits. When offering products to users, it is important to verify the source from which they have been acquired and whether they are licensed goods or copies, since selling counterfeits could lead to claims from trademark owners. Even when dealing with licensed products, it is important for businesses to purchase them from an authorized distributor, since the trademark owner may have designated a number of exclusive distributors within a specific territory, therefore barring anyone else from importing products bearing the corresponding trademark. In any event, if a product is purchased within a territory from an authorized dealer or from a third party that has acquired the product from one of those authorized dealers, usually no action can be brought against the purchaser in case it decides to resell said product, due to the exhaustion of the trademark right after the first acquisition or purchase within that territory. Patents, on the other hand, are used to protect technological inventions and processes. And in some jurisdictions, they can even protect business models. Aside from patentable inventions developed by an e-commerce business, for example, a payment method or specific technology, certain products may include patented technology. Consequently, a claim against a patent owner may give rise to an injunction from a judicial body setting forth the obligation to cease the commercialization of any infringing products. This could have a severe impact on an e-commerce business since part of its catalog would not be available any longer, thus losing part of its client base or part of their potential clients. Design rights, on the other hand, protect the actual appearance of a product. Together with trademarks, it is one of the most critical intellectual property rights in connection with products offered through electronic networks, since counterfeits are relatively common. Similar considerations as those detailed for trademarks would apply in many aspects. For example, the exhaustion of rights. Finally, just to finish off, we will very quickly discuss some cybersecurity and criminal law implications that an e-commerce business might face. Regarding cybersecurity, as we all know, the increasing number of data breaches and cyber attacks has led countries across the world to legally establish minimum cybersecurity standards for internet businesses. And although this field of law is relatively new, it is likely to grow exponentially in the near future, giving rise to a new set of regulations that must be taken into consideration by e-commerce businesses when conducting their activity. One of the main obligations for businesses is to notify the authorities in the event of cybersecurity incidents that could affect personal data. Therefore, it is advisable to have in place adequate organizational mechanisms to ensure that this obligation can be fulfilled within the legally established timeframe. For example, a very well-known case would be Ashley Madison, which was a dating platform. Ashley Madison suffered a cyber attack a couple of years ago, and most of its users' personal data was leaked into the internet. In this case, liability can come from claims from users and from public authorities enforcing data protection or cybersecurity regulations. And finally, we will very briefly discuss criminal law aspects that could affect an e-commerce business. Of course, as we have mentioned, the electronic networks through which e-commerce transactions take place are also used to commit crimes. Some of those crimes, such as fraud, can be tied directly to e-commerce, especially in C2C transactions, where users have to rely to a great extent on the good faith of each other. Criminal law can also have a decisive impact in B2C transactions, since users can try to take an unfair advantage of an e-commerce business by committing a crime. A very common one would be credit card fraud. And unlike other areas of law, enforceability of criminal law in an e-commerce context can be quite difficult due to its territorial nature. This means that if a crime is committed by a user in a territory, in a different territory to that of the e-commerce business that is the victim of that crime, it is very unlikely that the e-commerce platform will be able to actually take legal action against that user. Well, I would like to thank you for your attention, of course. We invite you to keep learning more about preventive law in JURÍDIA. And here you have my email address in case at Ethica, our law firm, in case we can be of any assistance to you. Again, thank you very much.